Hi everyone, welcome back to our final lecture of basic video and film production. Today we're going to be talking about legal issues for film, and we're going to start with a little exercise. I'm going to be going through a short script, and I'll pretend like I'm your legal advisor, so I will stop you every time I think there's a problem with legal clearances for this particular story. So I'm going to go ahead and try to put this on the full screen so you can see it. So, exterior Spago restaurant night, we'll stop right there. Spago restaurant, that's a well known restaurant. We'll have to get permission to shoot outside of that restaurant. A Rolls Royce, we'll stop there. Cars can be tricky. Most cars we don't have to worry about from a legal perspective because they're pretty generic. But let's say that Rolls Royce were to drive right up in the camera and we saw that emblem that was really distinctive, we'd have to get permission to use that. So Rolls Royce drives up and is greeted by Harry wearing the distinctive red and black uniform of a Spago valet. Okay, we got two things here to worry about. First, the name Harry. If there is actually a guy named Harry who works at Spago, we need to change that name because we want to make sure there's no misperception that he is being represented in this story. We also need to get permission to use that distinctive red and black uniform of a Spago valet. William Gates, okay, we probably want to stop right there because Bill Gates is a very famous person. We don't want to have any association with the real Bill Gates. Wearing an Armani suit. Now, this one is a little different because personally I wouldn't know an Armani suit from Men's Warehouse, but if it's something that's really distinct about this suit, you might want to get permission for it. Tanya Hilliard. This one is also a little maybe difficult to understand, but let's talk about this one for a second. If there is no one named Tanya Hilliard in the area that we're shooting, let's say we're shooting a film in New York City. And if there is no Tanya Hilliard, then we're good. Or if there's a bunch of Tanya Hilliards, we're good. The problem comes whenever we have maybe one or two Tanya Hilliards in a given area, and we might have some potential association with that person. So with names like this, either you want them to be very distinct where nobody has them, or very basic where a lot of people have them, so there's no connection there. Carrying a Gucci purse, definitely want to get permission for this because I'm guessing it has all those little big G's over the purse that are going to be identifiable. Exit the car and enter the restaurant. Okay, now we're interior Spago restaurant night. William and Tanya are greeted by Charles, the maitre d'. This is the same situation as Harry, the valet. Make sure there's no Charles, who is the maitre d' at Spago. Beautiful artwork adorns the walls of the restaurant. Artwork is a big problem. All that stuff is copyrighted, so you got to make sure you have permission to use everything we see, unless it's too difficult to see. And we'll talk about that one later. Music from a string quartet fills the room. Music is another huge problem whenever we're filming. And we're talking specifically about music rights a little bit later. Suddenly, a shot rings out. A man wearing a Nike cap and an NYPD shirt. Both of those wardrobe items are problematic because they're copyrighted, so we have to get permission for those. Falls to the ground. He gasps his final words. Don't eat Big Macs. That's a problem too because it's a defamatory comment against McDonald's, so we could get in potential trouble with them. Okay, so you see here in just a really short script, we've got all these different legal concerns that can pop up. So that's where we need to have somebody, and preferably an entertainment lawyer, look through our script and make sure we're not going to have any issues when it comes to filming. So let's just walk through some basics here. And the most basic thing we're going to talk about is what's called clearance. Clearance is just getting permission to use things that other people have ownership to. So let's talk about, I guess, a more legal definition. Whenever we do get clearance, we'll be having people sign release forms, most likely, that give us that permission to use whatever it is we're trying to use, be it music, art, or whatever. You have to be very careful that everything is cleared before you try to have it released, or else you could open yourself up to legal problems. You see an example right here, Hangover 2. Okay, you see the Mike Tyson tattoo. That was copyrighted artwork that they didn't have permission to use, so they were sued in this case over a clearance concern because they hadn't had that particular artwork cleared before filming. There's all kinds of great cases out there where films didn't get the proper permissions prior to release, and then their distribution was held up because they had to get all those things in order. And it's definitely more difficult to get permission after the fact than it is before the fact, because at that point they've kind of got you in a situation where you have no negotiating power. So be sure you're keeping track of all those things that you need to get permission to use. And let me just show you a list right here of some common clearance concerns. Okay, definitely anybody who appears on camera. Those are actors or featured extras. If it's deep background people who you really can't see, don't worry about it. But anybody who speaks or you see them really clearly on camera, they need to sign some kind of contract or release form. We already mentioned the character names. Phone books I know aren't used anymore, but you can check this, online as well. Just find out how many people in the area have a particular name. Um, I kind of like the rule if you have 0 people or more than 3 people with a name, then you're good to go. 1 to 3, that might be something you want to consider changing. Any kind of distinctive location, we need to get permission for that. And we already mentioned Spago, but that could be anything distinctive, any restaurant or store that has distinctive look to it. Props, wardrobe, any of that stuff that has logos on it, that can be an issue as long as it's prominent. Big Nike swoosh on a shirt, yeah, we got to get permission, but Nike shoes, where maybe you don't see the shoes so prominently, that probably would be less of an issue. Artwork, photos, that kind of stuff that's on the background of walls, that can be tricky, so get permission for that. Music, we've already talked about that. We'll talk about it more. And of course, anything defamatory, we've got to be careful with. Okay, so let's take a look at a case study here. There was a film that came out 1997 called The Devil's Advocate. Some of you may have seen it with Keanu Reeves and Al Pacino. And in this film, Al Pacino plays the devil, Keanu Reeves is his lawyer, and the devil has an office. And in this devil's office, there is a giant artwork on the wall. And you see it there on the right side, that kind of low resolution image. Okay, this film was released, and some people saw this and said, wait a second, that's on our church. That's something called Ex Nihilo, which is on the National Cathedral. And they said, you never got permission to use this. So this actually went to court. And just imagine you're the jury for this case, and they say, okay, do you think they stole this? Because the filmmakers claimed that, no, this was an original piece of art that we created specifically for the film. Well, if you're the jury and you look at these 2 images, I mean, you can see all kinds of identical elements to the 2 images. So clearly, the producers of this film stole that artwork without getting permission. So the jury did find that the producers of Devil's Advocate were guilty. They had to go back in and remove the sculpture, the artwork, from any subsequent release of the film. So certainly that was a situation where they should have got permission to use that. And probably if they did ask for permission, they probably would not have gotten it, because I'm guessing the church would not have wanted their film or their artwork associated with the devil. Okay, let's talk about music. Music, again, is a big problem, and it can be an expensive thing, especially for student filmmakers, to try to acquire music rights, because music can be pretty expensive. Whenever you approach getting music, it's not so simple as saying I want to go to, the artist and say, hey, can I use your song? Because a lot of times, especially for a prominent artist, there are all kinds of different levels that you might have to go through. But in general, the place that you're going to end up is a publisher, or usually they're called a performing rights organization, and they're going to be the ones who manage music rights. So you typically won't go to the artist or the label, you'd go straight to the pro. And right now, there's really two big ones. BMI and ASCAP are by far the biggest ones in the US, and they're going to manage all these licenses. But you don't just get one license when you're dealing with music for a film. You first have to get what's called a sync or a master license. And this gives you the right to use music in tandem with visuals. So that's one license you get. But then let's say you want to have this film exhibited, which of course you will want to. That's a different license called a performance license. And that's going to be for anything, streaming, broadcast, whatever. So you'll have these separate rights or licenses that you'll have to acquire for a song. And of course, the more prominent the artist and the more prominent the film, the bigger the money is going to be that you have to pay to get those rights. Now, for student filmmakers who want to go more cost effective, there are different licensing libraries out there that you can use. And we actually have what's called a buyout license at our school. It's called Atomica Music. And all the music that we have in our library, and there's thousands of songs in this library, you can use for your productions, your films, or things that go out on broadcast for TV shows that we'll be doing later. So you have the right to use that. But you got to make sure that you have the proper rights before you get that music out there. So you can go to any music library on the internet, and there's places where you can buy entire libraries, or you just buy one song, and then you're covered. You have clearance to use that particular cut of music. Sometimes you might even want to use just a part of a song, and that's called a needle drop license, where you pay a one-time fee just to use this section of a song in your film. So as you start kind of maybe moving forward to larger film productions, especially once you get to films that you're going to be making for Fault Line, you'll definitely want to make sure that you are getting music that's cleared. Because the one thing probably that gets student filmmakers the most, that gets them in the most trouble, is using music without permission. So we want to get in the habit of clearing our music rights, making sure that you are covered before that film of yours gets released to the world. Okay, here's a quick case study on music. For the longest time, the song Happy Birthday to You was just a nightmare for filmmakers because the rights of it were owned by these two sisters. You see them right there, the Hill sisters. And they were just vicious about enforcing the rights to their song. I mean, seriously, you couldn't go to a restaurant and have people sing Happy Birthday to You there. You notice whenever you used to go to the restaurant, they would make up some stupid happy birthday song that made no sense because they were trying to avoid using the real Happy Birthday to You song. And they made all kinds of money off of this. You can see there $2 million a year generated off the rights of this song. Well, very recently, you see there in 2016, finally a court declared that they were actually in the wrong the whole time. Now, the Hill sisters have long died, but those rights went over to Warner Music, and Warner Music was still trying to charge people for use of the song, but the court ruled that this should have been in the public domain long, long ago. You see the date there. I mean, the original publication date should have put this into public domain. So Warner had to pay a big fine, and now you are free to use the song Happy Birthday to You however you want because it is in the public domain. Okay, so just a quick kind of warning for all you filmmakers out there. Just be very conscious of what you're putting into the screen as far as music, art, logos, things like that. Really be aware of your production design and of your post-production to just ensure that you're not going to run into any problems uh, later with your film. Okay, so let's talk about some specific rights that you need to be aware of. And let's start with something called fair use. Fair use is kind of a generic term where you're allowed to use some copyrighted material without permission if you meet certain guidelines. And certain areas of fair use can include news reporting. So if you're doing a news story on a robbery that happened at McDonald's, you don't have to get permission from McDonald's to cover that story. You're reporting news, so that's covered by fair use. Educational use. If I want to show you a clip from a film or even use this image you see here on the screen right now, I don't have to get permission for that because I'm using it for educational purposes. Now there's limitations to that, of course. I can't go beyond the classroom with this, or I couldn't give you, you know, free copies of Stranger Things. That go beyond the scope of fair use. Things like Saturday Night Live or other kind of satire and criticism, that's all covered by fair use. That's why they can go on and do skits about real people and not get in trouble for it because it's covered through this statute. There's another thing called de minimis, and we'll give an example of de minimis here in a second. But if you've got something that is copyrighted, but it's so unsubstantial in its use, like maybe it's very brief or it's really hard to see, you would not need to get permission in that kind of situation. So let's take a look at an example of this. Maybe you've heard of the film Seven. This is a David Fincher film starring Brad Pitt. If you ever saw the title sequence for this film, it's got all these kind of crime scene photographs in the background, and they kind of come on screen pretty quickly, and they're a little bit blurry, but the photographs they used for that title sequence were actually copyrighted photos owned by an artist who discovered their use and sued the filmmakers for using his photographs without permission. So the case went to trial, and the court ruled de minimis in this case. And the reason why they ruled de minimis is because they were on screen for too short a time, they were out of focus, it was hard to identify them. Now, if they had been on screen longer or easier to identify, then they would have gotten in trouble, the filmmakers. But this was a de minimis situation. Now, there's no hard and fast rule for de minimis. You can't say, if it's over half a second, you're in trouble, and under half a second, you're fined. It doesn't work that way. It's kind of a judgment call based on each case. So don't try to push this, but also realize there is some protection for an out of focus artwork in the background. You probably are going to be okay with that because it's too hard to see. Okay, public domain. This is a pretty cool thing for artists because it allows for you to use things freely without having to get permission to use that in your own work. Let's talk about some examples here, and then we'll talk about the specifics of the rule. You see there an image from Huckleberry Finn. Let's say you ever go to Barnes and Noble or a bookstore, and maybe you have to read Huck Finn for a lit class that you're taking, and you're looking for copies of it, and you see 10 different versions of it there at the store from 10 different publishers. That's because Huckleberry Finn is in the public domain. Anybody who wants to can publish that work. And that's basically how public domain works. You can take those works, and Shakespeare, of course, falls into this, but a lot of music, Beethoven and Mozart, that's all public domain. So you can freely use this however you want to in your own work. Now, the thing with music, though, like stuff by Beethoven, sure, that's been over 95 years. You see, that's kind of the basic rule right now. 95 years is what places something in public domain. But let's say you use a work by Beethoven that was performed by the New York Philharmonic and they did that performance, 25 years ago. Well, the performance of that work is not in the public domain. That is copyrighted. So you'd have to get permission to use that specific performance. Or maybe somebody did a new arrangement of something. You'd have to get permission for that. So do be careful with music in that you would have to have somebody perform it yourself in order to be free and clear as far as public domain is concerned. Okay, here's another case study, and this is really the thing that changed public domain. Um, Steamboat Willie. This was the very first cartoon that Mickey Mouse appeared in. It came out in 1928, and of course, Mickey Mouse has since become the corporate identity of the Disney Corporation, and they got kind of worried because you see some of the different Copyright Acts here. The original Copyright Act was 56 years, which is pretty amazing. You could imagine some of the work that would be in public domain right now had that still be in existence. Like Beatles songs would start entering public domain right now, which is pretty cool. In 1976, it got pushed back to 75 years. But then you see there the Copyright Term Extension Act of 1998. Some people call this the Mickey Mouse Act because the Disney Corporation was starting to get scared because Mickey Mouse was getting close to entering the public domain. So they lobbied Congress and they got copyright extended to 95 years. So that's the one that's kind of established where we're at right now. Well, 95 years, it sounded pretty good back in 1998, but guess what? We're starting to get kind of close to Mickey Mouse entering public domain. You see right there, 2024. That's when things from 1928, including Steamboat Willie, will be entering the public domain. It's kind of cool to go and see what things have entered public domain. I think Rhapsody in Blue by George Gershwin, I think, is now in public domain, so that's free to use. And there's some other cool things. A lot of early Chaplin films are already in the public domain. And just imagine as we get even further out, even 15 years in the future, things like Wizard of Oz, Citizen Kane, those things will be entering the public domain, be free to use for anyone. Copyright. This is something that you have to protect your work. Copyright is basically for artists to make sure that their creative work has some kind of legal protection to it. Now, the second that you create anything, if you write a script or you make a short film, you have something called common law copyright immediately, meaning you don't have to ask anybody, you don't have to fill out any forms, you just have ownership to it. The problem with common law copyright is that it's hard to prove in court. So you definitely want to get what's called statutory copyright. This is official registration of your creative work through the US Copyright Office. Basically, copyright.gov, that's where you're going to go. You're going to upload whatever it is you have. I think the fee is $35 for a single work, so it's pretty affordable. If you do this, you're going to have a lot of benefits. For one, if you ever do have a case against your work, it's going to be much easier to receive damages. You're probably going to get more damages, and you won't have to worry about attorney fees because they're going to know you have an open and shut case. They're going to cover it. You don't have to pay for that. So I highly recommend for those of you who are starting to create, especially like screenplays. Some of you are in screenwriting right now. Maybe you're going to finish your script and you want to start sending it out for people to see. Before you send it out to anyone, make sure you get it registered through the Copyright Office. That's going to protect your work. We do not have the right to say horrible things about people. That's a protection that we don't have, especially whenever it falls into something we call libel. And some of you probably have talked about libel in your MC 101 class. And there are certain criteria that must be met to prove a libel case. And it is kind of hard to win a libel case. If somebody says something bad about you, it takes quite a bit to prove that it's libel and to get any kind of damages from that. So here's some basic tests to prove if something's libel. Okay, the statement has to be false. So let's say, for example, you say something really bad about a person, but it's true. The statement you make is true. Truth is absolute protection against libel. So let's say you're a reporter or a documentary filmmaker and you're telling a story, but what you're telling is the truth. You don't have to worry about libel. So I guess the lesson here is just always tell the truth in everything you create and you're going to be fine. But let's say you did say something that was false. Well, you also, or at least the person who's suing, has to also prove that they were damaged in some way by this. Either they lost income, it hurt their reputation, it caused emotional strain, whatever it might be. They have to prove that something bad happened to them as a result of your statement. And thirdly, another criteria we throw onto this is that the defendant, the person who made this statement, was negligent, meaning they didn't really try to find the truth. Let's say I'm going to do a story about Katie Holmes here, who you see. And let's say I reached out to her before I did this story and said, I'd like to get a statement about what I'm hearing about you being addicted to drugs. And I try to get the truth. And I keep getting rebuffed. Nobody ever responds. She never responds. I tried to find the truth. You could probably claim that I was not negligent in that case because I tried everything within my means, reasonable means, to try to get the truth. So that's another thing that has to be proven. And for a public figure like Katie Holmes, there's even a higher standard. It goes beyond something called negligence into something called malice, in which now we're doing it almost on purpose. We're trying to hurt this person by saying these false, damaging things. You see in the case here of Star Magazine, they said that she was addicted to drugs, which was false, damaging, and malicious. So she won. She won $50 million in this lawsuit. So again, just whenever you start creating your own work or you're doing your own reporting, whatever it might be, tell the truth and you're going to be fine. Okay, last thing. People have the right to their name, likeness, all those things. I can't open up like a store in Cape and stick a sign of LeBron James out front that says LeBron James only shops here at my store without getting permission for that. You have to get permission to use somebody's name, voice, likeness, whatever. And a good example of this is from the show Seinfeld. If you've ever seen the film or the show, you might know a character named George Costanza, and you see a picture of him right there. Well, when Jerry Seinfeld was in college, he had a friend named Michael Costanza. And Michael Costanza also happened to be short, fat, and bald, just like George. Well, Michael Costanza eventually sued the show for violation of privacy, basically using his name identity without his permission. You see the result of the court case right there in 1999. The court ruled that Michael didn't win, but the reason why is because of statute of limitations. He failed to file the lawsuit within that 1 year time frame that was allowed within New York. So if he would have filed this case sooner, he would have won. And if he had filed this case in another state, like California, for example, he probably would have won. And I think the lesson here is I think a lot of you, when you create work, you're going to be maybe using people in your life as inspiration for things. Just one simple thing you can do to protect yourself is just change the person's name. I mean, if they hadn't used the name Costanza, which is a very unique name, they probably would have been fine. And even just changing some aspect of the character, instead of being short, fat, and bald, maybe they're short, fat, and lots of hair, whatever. Find at least something tiny to make sure that there'll be no confusion that this person's based on another person, just to protect yourself. Okay, that's all we have for legal issues for film. I'll talk to you later.